Great. Hello, everyone, again, and welcome to this session, the first session of Broker and Attorney Open Mic. And I'm so excited about this. And I just wanted to introduce Russell first, which is our preferred closing attorney here in Georgia. And welcome, Russ.
Okay.
Hi, Carmen. I'm also excited about being here. And I hope that this is something that once the word gets out that more people tune into, because there's always a lot of questions that people have. And there's not always that many venues that you can get that information to the agents. So I consider this a win-win for everyone.
And thank you so much. We've been talking about this for a little bit and trying to figure it out how would be the best way to make ourselves available to you. I'm Carmen Delgado. I'm the broker here in Georgia. We have been, working together for more than 18 years or so. And I've been a broker for since 2013. And, hearing these issues that come up on contracts and things like that, we wanted to make ourselves available, like I said, to be able to share some ideas, provide some, ways to resolve issues that come up, before they are big issues. Okay, so basically that's what we are here for. And let me share some housekeeping matters just to make it easier for everyone in being able to enjoy this time together. It's only an hour, and we may not be able to resolve every issue, but we are gonna share some information with you. Okay, so first of all, please keep yourself muted, because that way, we don't want to hear, the noises, where depending on where you are and all that, and maybe we have to, repeat ourselves, and it will be better if we keep it muted. If you would like to ask questions, please feel free to do it. Use the, the icon to raise your hand, and we will be looking at that and make sure that your questions are answered. Okay, so we would love to, stay on topic. We are gonna introduce a topic every time, and if you have questions in regards to that topic, again, raise your hand. We will open the mic, and we continue to elaborate that until we finish. In the last 20 minutes of each session, we would like to, of course, open the mic again for general questions that are not related to that topic. Please refrain from mentioning names or agents' names, issues that, we don't want to hear that. Just let's create scenarios like we are, sharing ideas on one particular issue, even though you experience that. We don't want to mention any names because this is being recorded. And also, like I said, the last 20 minutes, of course, will be, for general questions. So we may or may not be able to answer your question today, but we will do the best possible to provide some insights and on those questions. If we think that this is a little bit, deeper, and we have to, and it will be a good subject for another session, we will do it. We will get information, so we will have a list of topics for future sessions. Okay, so basically we came up with the idea, hearing your cases, hearing your day-to-day situations and issues that arise on a transaction, and we would like to make sure that we will use those to help others, so you have the knowledge ahead of time and learn something new. If you learn something new today, right, Russell, we will be so happy. And that's
it benefits everyone.
Absolutely, absolutely. So I was sharing a quote with Russell a little while ago that I found interesting. It says, opinion is the medium between knowledge and ignorance. Again, opinion is the medium between knowledge and ignorance. And that's a quote from Plato. I don't know if I'm pronouncing it right, but or Plato. I don't know. What's the right pronunciation?
Plato, baby.
Plato.
Plato.
Plato. So, and this is very interesting, and I think that very useful to get started, because sometimes we have opinions about different issues and different information, and we think we know how to resolve issues, but it's better to get the knowledge, right? And knowledge is what makes us more professionals. Knowledge is what will help us in the future to help others to avoid issues that may compromise, you know, their money, may compromise the potential way to get a house or to get a property. So that's what we are here for. So we don't want to give you only opinions. We would like to share knowledge. And that's what we are here for. Okay, so Ross, what is the topic for today?
Well, I believe that, let me pull the topic out of the hat. I think we might have discussed quiet title.
Yes.
Quiet title actions, and how they affect real estate and why they are used.
Okay, and who knows? Does everyone knows or have heard anything about quiet title? Can you raise your hand? Have never heard that topic at all? Well, guess what? You know, I've been 18 years in the business, and only 2 or 3 years ago, I heard it for the first time, you know? And now Ross and I, we are dealing with another possible quiet title that is needed because of that. And I think that Paola raised their hand, so I'm assuming that you have heard about that, Paola. That's awesome. So what is quiet title? When is actually needed? What is the situation that I experienced a long time ago? It was, you know, some kids involved in the title, but Ross is going to be the one that will explain this in a deeper way. Ross.
Yes. Well, before I talk about quiet title, I want to take a couple of steps back and kind of explain what in the world it is that we do with title. Because I sometimes think that is a curiosity that most agents aren't quite certain they've ever had answered. Now, you get a contract signed and you have a buyer and a seller, and you present that to me. And I then examine the title. Now, mind you, most of the time, I am representing the mortgage company. In Georgia, the real estate attorney is representing the lender. But when we do title, the contract calls for the seller to be able to provide good and marketable title to the buyers. And we have the title, we get it back, we see problems. Now, in real life, the seller who owns the property has a property with title issues. And in real life, that seller should be going to another attorney to resolve the problem. But that slows everything down. So as a courtesy, not because we're representing the seller, but because we are trying to clear up a title issue that is, I won't say insignificant, but not needing any type of litigation, we will go as far as possible to resolve the problems on behalf of the seller at no additional charge, I should say. And this is simply to facilitate a timely closing. Otherwise, believe me, looking at most of the titles that we see, half of the contracts that you send would have to be sent to another attorney for clearance. So that is step one or level one, and that is that we can resolve most of the issues in-house. And sometimes it takes more time than others. Sometimes it takes a lot of parties who are not even involved in the closing to get together and resolve it. Sometimes it could be as easy as the seller providing a title insurance policy that they purchased, which shows that that title has been insured and protected, and a subsequent title company has to accept it. They, even if there's something incorrect on it, they are still obligated to accept it. So that's what we do. We look for the solutions. We work as quickly as possible to get the issue solved. But every now and then, it goes beyond that. And some problems simply cannot be fixed. I'm trying to think of a few different situations. I'll give you a for instance, one that is just happening now. We have a piece of property and the title has been passed from party to party, never through a law firm, always handmade deeds recorded, and everybody involved was acting in good faith. They thought that they were doing everything correctly. Unfortunately, they didn't understand how probate works in Georgia, and that when some of these parties who were on title died, that their estate needed to have been resolved before they could pass good title. And when you have a situation where it's not just one person who needs to probate, but a dozen or more, because the family tree is very large, and when one person died, then all 10 children suddenly inherited the property, and 7 children have died, and 4 of them had children. Well, all of a sudden you have this mess, this monstrosity of an issue where you would need everyone to cooperate and in a timely manner sign deeds and accept the fact that they don't have an interest in the property even. This can be almost impossible. And there has to be something in place, somewhere to go when you reach a dead end as far as what you can do just trying to gather people together and resolve a problem. And that solution is called a quiet title action, which is filed in the county where the property is situated. And basically, quiet title means just that if there is a lot of noise around your title, this action will quiet that noise. And essentially, the court determines who owns the property, what the property boundaries are, and they pass an order. They give an order that the title is now as such. And once the court orders it, that's the way it is. And it is, in some cases, actually a shortcut to getting big problems resolved.
Awesome.
So that is, in a nutshell, what a quiet title action is.
Awesome. And you have mentioned different terminology that
yes.
Let's go and prepare you know, a checklist to see if everyone here understands, you know, those terminologies. So when you said, of course, that, you know, the title search is done and you have to go back and make sure that everyone that have gone through that house ownership, you know, the title company has complete knowledge and there is no breaking, you know, or broken information
Yes.
In that chain of ownership. So that's basically
Correct.
what the title search is all about, right?
It is. The title search, even the way that it's done, explains how it works. You go from the current owner and you say, well, who did you get it from? And you find that deed. And then you say, and where did you get that property from? And you find that deed. And you keep moving backwards in time until you have.
How long back do you have to go on a title search?
The title company requires a 50-year search. Yes. 50 years. And I needn't tell you that sometimes the descriptions of our property, if you look at how property is described, sometimes, especially in rural areas, it is very hard to determine what the property lines are because 50 years ago, they weren't as precise as we are now. And so this is why sometimes there's some gray area as far as who owned what property and when. And sometimes we can resolve it ourselves. Many times we cannot.
Wow. So basically, when you were describing the quiet title and what it is, you mentioned that sometimes, you know, people do it in a different way, thinking that they are doing it the right way, which is contacting a closing attorney, a real estate closing attorney, to handle that closing and make sure that everything, it won't affect the title, right? The title itself. So what you have found recently is that some people, you know, pass this property between family members, and maybe they did not record the title in the right way, so a quiet title is needed, right?
That is actually, yes. And some of that, Carmen, though, is dependent on when this happened. If it happened in the past 5 or 10 years, the parties are probably still alive. Possibly we can contact them, and possibly they can take action themselves without having us having to take it to court for a quiet title.
Mhm.
But if the issues happened 30, 40, 50 years ago, there's absolutely no way for anyone to be able to find these people and to get everyone on the same page. So
Okay,
that's where quiet title comes in most handy.
awesome. And of course, the quiet title, what it's gonna do is try to resolve that issue, so we have a good and marketable title again, right?
Exactly. Yes. A little bit more, because I've talked to you about probate and about families not preparing deeds right and all of that. That is only one type of issue that is addressed by quiet title. For instance, if there is a forgery, someone forged a deed, and occasionally we see that someone stepped in and forged a deed. Or, for example, if the boundary lines are in dispute, and one neighbor claims title to the property that you are trying to close on, and you have absolutely no way to know because the descriptions are so vague, then you go and do a quiet title action. And another thing, and another very important type of title that always requires a quiet title, is when a person buys property via a tax deed. So let's say that you go to the courthouse steps and you bid, and you're the highest bidder on a piece of property where the taxes were not paid, and you make that payment in full, and then the tax commissioner gives you the deed title to the property. Well, for a year, that's the person who should have paid those taxes can repay them.
And
But
one,
if a year,
1 year, right?
1 year, and there is a substantial penalty for them to do that. There's no doubt about it. But if you are a purchaser at a tax sale in Georgia, you have to basically hold that title for 1 year before you can do anything with it. And then there is a method in the statute that tells you all the steps you have to take to clarify, to get good title and to remove the other party. Now, I won't get in detail about tax deeds now, but I'm just wanting to point this out, that even in Georgia, once you get to the point where you have done everything that the statute requires you to do, the title insurance company does not recognize that as good and marketable title, because the statute allows a lot of opportunity for fraud and mischief. And they have many, many times allowed or insured a title that they did not have a quiet title action with. And other parties came in and said, wait a minute, nobody notified me. Or so it is the system that they have required us to honor, is that if you have a tax deed, you better go and take it. If you want to sell that property, you better take it to someone, to an attorney, to handle a quiet title.
Amazing, amazing. Thank you for that explanation. And I'm making notes here just for us to, you know, go a little deeper in those terminologies that some of you probably are hearing from the first time. But in regards to the tax deeds, we have here some agents that are working with investors, you know,
Yes.
and I don't know if they are aware of, or if those investors are getting properties on tax sales. But it is important for them to understand that some of that property, they cannot resell it, right, in the first year because of what you just said. You know, some previous owners can claim it back if they pay the debt, right?
That is correct. That is correct. And I will say that over the years, I've had dozens, hundreds maybe, of files where the seller took title in that way and had been instructed that everything that they had done was appropriate and final, only to find out in my office, it's not enough.
Hmm.
You need to go to the court. They need to make sure that no one else in the world can claim title to that land.
Wow. Wow. Okay, so you see, there is a lot of details that are related to title, and probably we are just aware that the attorney does their job, you know, they do the title search, and hopefully we are not gonna experience any issue with the titles, but there are several issues, and that's precisely why we are here for. We would like to bring those topics to you, so you will get a little deeper on those topics, and will be able to know ahead of time before you even experience that issue yourself. So, wow. So you also mentioned that probate court.
Yes.
And I don't know, some of our agents probably have not experienced that yet, but in my case, in those specific quiet titles that we are working on, or we worked in the past, and the one that we are working on right now, it was needed because, you know, children were on the title as well, and
Yeah.
that's when probate court has a say so, and,
Yes.
and probate courts may be involved because of other issues. Can you elaborate a little bit more in that regard?
Well, if there's children on a title,
Mhm.
then you have the issue that a child cannot sign a deed. A child cannot bind a contract.
Mhm.
So someone has to be appointed for that child, and it's not the parent, because the court has to check to be sure that the sale of the property is in the best interest of the minor child.
Mhm.
So they appoint a guardian ad litem, is what it's called,
Mhm.
to stand in the place of the child to make sure that the proper value is being obtained by the selling party, and to protect the young person.
Mhm.
It's often why it does. You know, a child can be on title, but it can cause so many problems later that we always instruct people not to put their minor children on the title. Wait until they reach majority and then do whatever you want, but don't do it when they're not of age,
And
below 18.
there are other resources, right? That if a family would like to put children on title, they have a way to do it. When they do, you know, what's the other?
Trust? No.
The trust, right?
Trust.
The
Yes.
trust.
Yes, there's many different avenues available, but I think when this happens, this is normally not a savvy individual that is doing it. It's someone who just doesn't realize that the laws will require them to go through so much, I would just say, hassle in the future if they ever want to sell that property. So it's mainly people who are doing things all on their own without seeking any counsel.
Mhm. Yes, yes, and that's precisely what we don't want to happen to any of you or any of the families that you are helping. That you get the knowledge, so you are, you know, on guard basically before this happened to you. And you also mentioned boundary lines, that would be maybe an issue that come up that a quiet title can help. Can you
Yes.
elaborate a little bit more?
Sure. Again, and I'll just use the example that I used before. Now, you're not going to have a boundary line dispute in a subdivision because a subdivision plat has been recorded before any lots have been sold, and all of those lots are well defined.
Mhm.
You may, however, have boundary line disputes, and frequently will, in the rural areas for many reasons, because it's our system is such that we don't necessarily, not everything matches together. Um, one person can own a piece of property and rely on a survey from 1972 of their land. And another person buys the property next door and they have a survey done and it's 30 years later and the lines are different. And somehow they are supposed to correspond to each other. But there's always little gaps and little overlaps that cannot be defined. Now, if every time this happened, we looked to all of the neighboring properties and said, we need boundary line agreements. This would be difficult because you would suddenly be calling in neighbors. And a lot of times neighbors don't want to be helpful. They don't want to do anything at all. So if you have a case where the boundary lines are simply not at all matching up and the parties cannot agree to a boundary line that is in common, then one of the parties needs to go to have a quiet title action done for the court to look at it and determine over time what the intention was and where the actual boundary line will be.
Awesome. Awesome. Okay, so let's go in the next 10 minutes or so. Let's go back to the quiet title process itself. What it is, how it is recorded. I know that you and I have discussed this with another colleague that you have that is in the area. He specializes in that process because it takes time, right?
It does.
Let's talk about a little bit about the process so agents will know once you identify, okay, a quiet title might be beneficial in this case, how it is done.
Okay. I'll start off by saying that although I'm a full-fledged attorney and could be going to court and doing this, many years ago, I decided that I would only handle the settlement part of this and not go to court. It was really hard to do closings in the afternoon in court before or after. It just sometimes it just didn't work. Okay. So over time, I've accumulated a number of colleagues that do go to court. I call it litigation. It's when an attorney goes to court, they're litigators. And I know several in the area that handle quiet title. They are real estate attorneys, but they are real estate litigators. So when a title gets to the point where I can't help any longer, I typically give the parties at least a couple of different choices to talk to these attorneys and see what it will cost and how long it will take. Now, generally speaking, a quiet title action can last anywhere from, I'll just say 2 to 3 months is probably the most normal. But some of the more complicated, some of the more just egregious problems might take up to a year. So let me tell you, if you have a contract and you have a buyer who's itching to get into that property and the attorney tells you we have a quiet title action that's going to have to happen, expect delays and be forewarned. And don't think that it's the attorney trying to extend the closing date, which a lot of people don't understand. We don't want it. We don't want to send that file to a litigator. We want to close it. That's what we want. And I mean, not to be cavalier, but we all don't get paid until that closes. So sending it away doesn't do me any good either. But if it has to be, it has to be. And at least if your agents are aware of what we're doing and why, they will understand and be able to make better informed decisions about their client.
Of course, and each case is different, like you said at the beginning. Each case might be what we are discussing here is just in general terms, but it all depends on who's involved, how long back of those people that are they didn't do what was right in the title. Yes. When was it done? In order for the closing attorney or the attorney that is going to handle that quiet title action can if he can find those people, if the people are alive,
right.
there are
Yes.
minors in the title. I mean, there are several different ways to get it done, and depending on that is how long it's gonna take, right?
That's right. Now, what the process is, just in general, a person, a plaintiff, files a quiet title in the Superior Court, where the county, where the property is located, and the judge of the Superior Court appoints what's called a special master. They're basically real estate experts, mainly real estate attorneys that come in and handle this for the court. But that special master then accumulates all of the data, title examinations, all the information that can be compiled. And then based on what they discover, they make a determination to the court, and the court makes an order. In the process, the person directly, sometimes there's a defendant, for instance, boundary line. It's the person whose boundary line you're sharing that is in question. They are the defendant, but, and they will be served just like any lawsuit, but they also do what's called publication, which is putting it in the county newspaper saying, this property, we have a question about the title. If you know anything, come to the court or forever hold your peace. And that's why quiet title, the type of action that is required in Georgia, is called against the world. So it's quieting title against everyone else in the world. They can never come, even if they were in China when all of it was happening. It doesn't matter. Once an order is rendered, they're out of the equation. So that's kind of how it works.
So how long is that publication live? So trying to reach everyone in the world to know that an action, quiet title action is being recorded.
Typically 4 to 6 weeks is the time period of publication. And it's all done during the period of time that the special master is accumulating his information. And sometimes that's a piece of information that he gets or she gets. Is somebody who has read the paper and said, I used to own that property, or I am familiar with that property.
So I remember that once the county, for example, when they do public hearings, they have a similar process, you know, that they have to reach out to the community and they have to run those ads for a certain amount of time. So it will be kind of similar, but is this being done in the newspaper? Is this being done online? How does, because now we have the technology. So how is it done?
I think it's done both. Okay. If there's print ads, it's definitely in the print edition of the newspaper. But I think the foreclosures and the judicial notices are also published online in the official county tribunal newspaper. And every county has designated one newspaper or publisher as their county tribunal.
Awesome. And I have one more question to finish those 10 minutes that I told you. The title insurance policy, which is one that when you identify that there is an issue in the title, is the company that said, hey, this is not an insurable title. That's why we need to resolve this in order to make sure that this is a good and marketable title. Can you elaborate how this is identified by that title insurance company?
That would be through us. Now, we are the agents. The closing attorneys in Georgia are the title insurance agents. So when we search a title and we attempt to fix a title, when we do that, if we run into a dead end, with experience, we know sometimes in advance that this is not going to go anywhere. But we'll still give it a shot if there are any avenues available. But if not, we'll send the whole file or the whole title to the title insurance company. And we will ask them, what are you going to require of us to insure this title? We don't make that determination. They make the determination, the underwriters at the title company. Okay. Sometimes the title company will say, nah, doesn't look too bad. We'll go ahead and insure over it. Other times they say, this is a problem. We cannot insure unless you get a court order via quiet title. And that's when we let all the parties know this is the determination of the title company.
Of course, and for general knowledge, the title insurance policy is the one that the client, of course, we will love for them to get at the closing table, because that will protect them in order, you know, if they find anything later on after the closing, that policy will protect them, and it's basically kind of having a warranty, right?
Yes. And actually, you raise a very interesting point, Carmen. Now, most of the time, as I say, we have a lender involved. And the lender is the one getting the title insurance, and sure, the buyer will as well. But the lender, there is no option there. They have to get it, and they have to have good title. So when there's a loan involved and we have a bad title, there is nothing that can be done. It has to be cured before we can close that loan. Now let's look at something a little different. What if your buyer is paying cash? And what if your buyer says, I don't care and I don't want title insurance? I'll take my risk. Well, I hate to close those because I know what they're going to encounter in the future.
Mhm.
But it can be done. I just wouldn't recommend it. It puts everyone in peril. And later on, when they realize that they've made a critical error, then they're going to be upset. And you don't want your client, and I don't want your client to be upset in 5 years or 3 years or 2 years when they try to sell the property that they passed off, not concerned at that moment.
And it's interesting that you mentioned that.
Yes, I will say that a lot of buyers are only wanting to get into this house. They've located the home. They found it at the price that they want to pay. They wanted to close it in 10 days. You know, everybody's rushing to get everything done for the buyer. And then all of a sudden the attorney says, stop everything. You need a quiet title action. It's going to take 3 months. I understand that in a very practical sense, that's not words anyone wants to hear. But the alternative of buying a property and then finding out when you're trying to sell it that you can't do anything and now you have to pay for the quiet title is not a pleasant one for anyone. So I want agents to understand it's a last resort, but sometimes it has to be taken.
And let me share, you know, why I learned about this quiet title through Ross. It was what happened precisely 2 or 3 years ago. And you know, a client was buying a piece of property, you know, it was a ruin type of house, you know, on land on 5 acres. And basically we were, of course, I was with the buyer, but on the other side, they were going through probate court issues because there were minors on title and all that. And in that case, we received title insurance. And that's what my client felt, that it was okay for us to close because it was a cash deal. Knowing later that 2 years later, when we tried to sell it, is when we found all this issue with the chain of title, and that we did not actually, and you know, found the title insurance that we were supposed, I mean, that the client were supposed to receive. Remember? And that's why
God, yes.
to sell it, we needed to go through the quiet title process to see if those minors that were involved, which were now, you know, older, the attorney needed to contact them in order to resolve the issue. And it took a couple of months, you know, I think that 4 months at least for that to happen. So that's how I learned about quiet titles. It's not when they bought it, it's when they tried to sell it that this whole issue arose. So yeah, it's amazing.
With quiet title, consider that there are many problems that can be solved There are many, though, that there's just nothing that anyone can do. It has to go to court, or a piece of property will never be able to be sold by contract. It would be impossible. So there has to be a last resort. And fortunately, we do have a last resort at the Superior Court level.
Of course, and it will not be able to be sold and insured, you know, and we don't want that for our clients, of course. That's an amazing topic, and I hope that it will be enlightening for everyone here in the call. And I think that now we are ready to open the mic to see if there is anyone that has questions about this topic in particular. If there is anything that you would like to, you know, clarified, or something that needs to be explained in a deeper way. Who has any question? I think that was okay, Darlene. Yes.
Yes. Just going over what he said, I just want to make sure I didn't miss something. I think I did, though. That example that you gave where it happened 2 or 3 years ago, they didn't notice that in the title search when they were transacting the property in the beginning?
Well, 2 or 3 years
They don't
before,
find it?
somebody else had done that closing. And I don't want to throw anybody under the bus, but it was a mess.
Yes.
The law firm that handled that, if I recall, didn't really do what they were supposed to do.
And actually,
And
we find that closing attorney when we were dealing with the quiet title. We look back 2 years back, they were not opened, and that was
Yeah.
it.
that was the other problem. They should have been able to help us at that point, but they didn't exist anymore, and they had created a terrible problem for the owner. They were supposed to have given the title insurance, and if I recall, they had even paid for the title insurance.
They paid.
Yep.
They are paid.
But-
and forgot
But they didn't get a policy, and the reason they didn't is because there were still terrible issues that were left unresolved.
So in this case, Ross, we can say, and this is a term that also you mentioned, there was probably fraud, you know, in the way that they handled the closing, and they
Mhm.
promised the buyer, we don't have the title insurance. Hey, listen, we don't have the title insurance, but that will be mailed out to you. And that's what happened to the buyer, and he never got it. So in that sense, you know, the clients there are supposed to receive the policy, right, at closing table?
Yet either at the closing table or after the deed is recorded. Both times are acceptable, and different companies do it in different ways.
Okay. Did that answer
I guess
your
that's why they closed.
Mhm.
Yeah,
Obviously,
but
why they
that's the
closed
thing.
that.
And you know what's really sad is those people, they thought they had a title insurance policy.
Yep.
And if they had, even if there had been a problem and that other law firm hadn't fixed it, the fact that they issued a title policy would have protected those people. So it was a really sad situation for them. That should never have happened the way it did. And I like to say it's why the company that does your closing, the law firm that you choose, is very important. You have to be able to trust them and be able to work with them.
And even if you need second opinions, you know, if you're going through something and the seller selected the closing attorney, and then you find yourself in the middle of something that you don't feel comfortable, hey, that's what we are here for. Don't stay like, okay, this is probably normal. Because that's what happened to me in that case, you know, and I was representing the buyer, and I found like, they chose the attorney, but it didn't ring a bell to me that something was not right. So it can happen. It can happen. So we would like to prevent that happen to you. Paola, you have a question.
Yeah, I have two. One with the tax lien. For example, my seller is gonna sell this house, and he didn't pay the taxes from November from last year. He bought it last year in May.
Okay.
So what happens if we are gonna list the house in 1 month and somebody pay the tax?
That's a problem. That could be a problem. Now, they do have to notify the owner of the fact that the tax bill is delinquent. And normally 1 year it being late isn't enough for them to do a tax lien foreclosure. But that's not to say that it couldn't happen. So you're saying that someone bought the property end of the year and those taxes are still not paid from last year, and now
No,
you're
no,
going to list the property.
yeah, we purchased the house in May,
Okay,
but forgot to pay it in November, and I told him you have to pay the taxes, but I don't know. At this moment, I don't know if he really paid the taxes or not.
I see.
It's
Well,
January, so we are
if
early in the process, right?
Sorry?
That is January. If we are early in the process, if you wait until, you know, the spring or so, it will be a bigger issue, I guess.
correct. And listen, if you'd like to send an email or something and give me the property address, I can look online and tell you if the taxes have been paid on that property. And if they're not, then you at least know that it is very important that they get paid as soon as possible, so there will be no tax lien. Now, to be honest with you, here's what would happen. Let's say that somebody did, in fact, have a tax lien placed on that property. Well, the seller would sell the property, but out of their pocket, they would have to pay that tax lien penalty at the closing to clear that title. It would still be within that 1 year, so it can be resolved simply by paying money. But it could be a significant amount, and if the seller doesn't have it in their pocket, then you have a problem at closing.
Okay. Okay, thank you.
No problem. And if you get me that information, I'll gladly look for you just to make sure that you don't have to worry about something that's already been resolved.
Okay, thank you.
Okay.
Awesome.
And I have another question, but I forgot it.
Well, you can connect again. I think that Alex has a question, and then I don't know, Darlene, if you have another question. Okay, let me go to Alex first, and then we'll go to you, Darlene.
Good afternoon, everybody. It's not. I'm just trying to follow up on the previous colleague, the issue of the house buying in a tax lien. I just got a question, just to make sure.
Okay.
You said that you gotta wait a year, correct?
If you're the
order
tax
to-
lien, yes.
If
Yes.
I buy the house in a tax lien, I gotta wait a year, correct? In
You-
order to sell it, or I cannot sell it before?
You do not have good title to the property during the first year after the tax sale.
Okay.
Because the former owner or the person who did not pay the tax bill, they have a whole year to redeem, it's called. They have a right to redeem. They can go and pay the funds and the penalty, and you have to give them a quitclaim deed back to give them back their full title. So that you're right. So that first year, nothing can do
Nothing
anything.
can be done. Correct.
in fact,
And that's what I understood, because I was a little bit confused. That's what I understood. Kind of know a little bit about how the process works. Because if the buyer comes and if the previous owner says, here, I'm ready to pay my taxes, they gotta pay an interest to whoever bought the house. Okay, but now thanks for the clarification. So now I know that you guys do have to wait a year.
And I will say, not to just go off on tax sales, but the penalties are very, very high. So if you are an investor, it's a good deal, because if you either get the title to the home or the property, or you get a 20% interest penalty. So for an investor, it's always a good idea. But a lot of people are getting in the investment business who are not fully aware of what the next steps in the process are. So it's good that you are familiar with it and you pass that on. But if you ever have any particular questions, feel free to reach out to me. I'd be more than happy to advise you.
Wow.
Thank you. And just one more question before I know. I'm sorry.
Sure.
Just one more.
You're fine.
It comes when two people are buying the house,
Yes.
in a regular process. I got asked a question. I kind of know the answer, but I wasn't sure, so I want to be sure now.
Yes.
How soon can the other person get taken out of the title? Can they do it at closing, or do they have to wait a certain amount of time?
It depends on the lender.
Okay.
I, fully legally speaking, a transfer, let's just say to your spouse at the closing table, is already what they would say it goes against what the security deed allows you to do, which is transfer title to someone else before the loan is paid off without the lender's permission. So every time it's done, there's, it's not quite legally appropriate. However, lenders, as a matter of course, practically speaking, they don't care if you do that and put half an interest in your spouse or someone else. It doesn't, you'll never get foreclosed on for that. But a lot of closing attorneys, because at closing, they represent the lender for that transaction, they don't want to do another deed because they don't want to be doing something that violates something in the lender's paperwork. But the day afterwards, if somebody comes in and says, I'm here, I was here yesterday, can you do a deed for me? Well, yes, we can, because we don't represent the lender today. So it's kind of a silly dance that we have to have. And I hate that I don't have a 100% great answer for you. Everybody's going to do it different. And by the way, I had a lender, they're no longer in business, but I had a lender where the owner told me, never do a deed at closing. You can do it any other time, but not at closing. So many times I'll ask the lender, is it okay that we do this before we do?
Perfect answer. Thank you.
Awesome.
You betcha.
Awesome. Darlene, going back to you. Unmute yourself.
I was going back to the part about the 4 to 6 weeks, I think you said on the publication.
Yeah.
I missed the part that is, do they have 4 to 6 weeks to respond, or they have 4 to 6 weeks to run the ad?
4 to 6 weeks to run the ad.
Run the ad. That's
right.
Okay.
Exactly. Yes. And it tells when there's going to be a hearing, and it gives all the details of the case. So if somebody gets the newspaper at that time and notices that they have an interest or have a familiarity, then they can make their presence known.
Awesome. Awesome. Good question, Darlene. Anyone else that has a question in regards to this topic or any other topic? We just have
Yes, I have one.
Oh,
Good.
I just confirmed with my client. Yeah, he forgot to pay the taxes.
Okay. Okay. Well, did he buy it with cash?
Yes.
Because what happens, and it's not really nice to these guys that buy property with cash, but the tax bill many times doesn't go to them directly. It goes to the owner who owned it on January 1st. So it could well be that he didn't get the taxes. I don't know, but it happens frequently. So as long as he can go in and pay the taxes in full, it would probably be best for you if he did that before he listed the property.
Yeah, because we have a closing this week.
Oh, this week?
Yes.
Oh, so he's selling this week?
Yes.
Well, I don't think it's going to be a problem. Beyond now, I would say it gets scarier with each passing day, what could happen. But if the taxes for 2023 were not paid, then whoever is doing the closing will see that, and they will collect the full amount plus penalties and send that to the to the tax office.
right.
So it probably will be done at closing, but you may want to you might want to advise the closing attorney that please make sure that 2023 taxes are taken care of at closing.
Okay, okay. Let me.
Yeah.
Okay. Thank you so much. Yes.
You're welcome.
And at least it's at the beginning of the year, so normally the court, when they or the counties, when they send those invoices, they of course advise that there is a certain period of time where they can collect, penalties and things like that, and they are not gonna take that.
Yeah, but what if somebody bought the lien?
No, I don't think that it will be that early in the process, because I mean, normally they have until December the 31st or so without penalties, and then is when the penalties start. So it's too early in the process, in my opinion. I don't know, Ross.
It probably is too early in the process for a tax lien foreclosure.
Mhm.
The party who is delinquent has to be notified. There are ads run in the newspaper for that by the tax office, that there will be a foreclosure sale the next Tuesday on the courthouse steps, just like a normal foreclosure. It's just over the taxes and not the other part, though. So it's not like a lender foreclosing, it's a tax lien foreclosure. So the process typically takes a few months before you'd even have that property offered on the courthouse steps. So it always matters that, in fact, if you're doing a listing, I would imagine that making sure that the taxes have been paid up to date should be something that you inquire about and verify.
Okay.
But that's probably a good question to ask the seller before we even list the property, right?
Yes.
Awesome.
Yeah, nor with investor that they always, or with hard money or cash. It's
Yeah.
really.
And honestly, most of the investors are aware that they have some grace period, and maybe they are trying to, even when they forget, probably they know that there is a way to get that done at closing table.
Exactly. And particularly now, this early in the year, they're probably like, I don't want to, it's a hassle to go and do this, or I don't want to take this out of my money. I'll just take it out of my proceeds, much easier. It's, yeah, I see it all the time.
Yeah. Okay. We are just done with the first session. That's
Wow.
If you have any question whatsoever, go back to the My Agent account. The information that we put in My Agent account, the post is what I was trying to find. And there is an email there, which is my broker's email. If you have any question that we would like to address in future sessions, please do so. That's what is going to give us some content for future conversations that we are going to have. And we would love to have this done every Monday at the same time, just to get the week started with the right foot, trying to go deeper in subjects that sometimes we don't talk all the time, but it can be very helpful for you to get that knowledge. So if you have any question whatsoever, please use that email, and I will be collecting those questions and prepare for, to discuss it with Ross.
Okay. Thank you so much.
I want to thank everyone too. I think that coordination between the closing attorney and the agent, and just a basic understanding of what we do, is very important, and actually makes things go much more smoothly when everyone is aware. So I thank everyone for coming. Tell others to do the same. The more knowledge that we share, the more knowledge that we carry, the better we can advise our clients and the smoother our closings will be. So thank you for joining us today.
Yeah.
Thank you.
And honestly, it's our objective to discuss as many topics as possible and make it fun and make it, in this relaxed environment that, there is no way that we are not going to hear your questions. We will not share that knowledge and be able to go deeper in those topics. So thank you so much for connecting today, and please share that information with others. Hopefully we are going to put the recordings in My Agent account, so more agents will have this session of today. And we'll see you next Monday.
Thank
Bye-bye,
you.
everyone.
You're welcome.
Thank you.
Bye.